Hey everyone, welcome back to another episode of the Ask Amity Show. And today we want to talk about how to keep your children's spouses from your trust assets. So you and your spouse have worked really hard to save up money and assets and would like your children to inherit them when you pass away. According to California law, inheritance are separate property of each spouse and are not community property. Therefore, your child's spouse has no rights to the inheritance. You can learn more about that episode linked above. However, parents may still have concerns over a child's choice in spouse or life partner and worry that a future divorce could result in an ex-spouse retaining a portion of their hard-earned assets. So fortunately, there are some estate planning tools that can be utilized to address these concerns.
So certain options for you in planning out your estate, if you intend to leave it for your child. Guarding against a child's possible divorce is a unique issue that will benefit from the help of experienced professionals. And some of the options that we've suggested for some of our clients are as follows. So number one is put your child's share of their assets into your revocable trust. So basically, you would plan for, upon your death, your child would receive a certain portion of your assets. But this distribution of the trust principal only happens at a later date, such as when your child turns 45, 50, and 55. So you can choose any age that you feel is appropriate. This may help mitigate the risk of a divorced spouse taking a share of your assets from your child's divorce. So if it's staggered and let's say they get married before the entire trust asset is supposed to be distributed to your child, then that spouse would not be able to claim any of these assets that have yet to be distributed. So that's kind of the idea, is to stagger the distribution. Second kind of option or tool is for your trust actually to hold your child's share for their entire lifetime. Example of this is if you own perhaps a home that you want to leave to your child, you can only give that child rights to reside in that property for his or her lifetime. So instead of transferring title entirely to your child, the title of that house would remain in the trust with your child as a lifetime, occupant with that right to occupy that property. And then upon your child's passing, the ultimate and final beneficiary would perhaps be your grandchild. So then the title would actually transfer out from the trust to your grandchild, basically bypassing your children in case of a divorce. So again, since title was not under your children's name or your child's name, it remained in your trust. Your child only had occupancy rights. So therefore, his or her spouse upon divorce would not be able to claim a portion of that property or inheritance. Another tool would be creating an irrevocable trust for your child's benefit. There are certain setbacks with this type of trust because it's less flexible. You have to really look at the details of creating this type of trust to best protect yourself and also your child from possible creditors and also their spouse.
So outside from creating trusts in order to protect the inheritance, what your child can do actually is to draft a prenup. A prenup agreement is a legally binding document entered into by a couple planning to get married. So the agreement sets forth terms of debt and asset division between the couple should they decide to get a divorce. The agreement may cover assets or debts brought into the marriage and any assets or debts acquired during the marriage. Prenup agreements are generally valid upon marriage so long as they comply with California law. These agreements can be beneficial under the following circumstances. Either of you have been previously married, either of you have children from a previous relationship, one of you has significant wealth, when either of you or both of you own a business, or when there's wide and diverse assets are being brought into the marriage.
Another agreement would be a postnuptial agreement. So postnuptial agreements are signed after a couple is married. They're generally permitted within specific parameters under California law. These agreements are a little different because couples are already married, and unlike unmarried couples, married spouses have a fiduciary duty to each other. Fiduciary duty means that you and your spouse must act in good faith and each other's best interests. Postnuptial agreements are often entered under certain circumstances. If you were planning to enter a prenup but did not get it done before your wedding, perhaps your financial situation changed and one spouse came into an unforeseen or unexpected sum of money. You want to make it clear that certain assets are not marital property, such as inheritance. Inheritance is generally considered considered separate property in California, but when it is combined with marital property, there may be room for community property arguments. A postnuptial agreement may make it clear that an inheritance is to remain separate property. When one spouse's assets are significantly changed during the marriage, a postnup can help account for that. So for instance, if somebody comes into a large inheritance suddenly, passed to one of the spouses, they may wish to make this postnuptial agreement basically to solidify and confirm that both spouses agree that this inheritance remains separate property. In California, inheritance, again, is typically viewed as separate property. However, there are some exceptions and also situations that may cause commingling of these assets. So it's less clear, how much of it remains separate. So after years of marriage, it may be hard to properly evaluate the inheritance if it's combined with your joint assets and whatnot. Perhaps having a postnuptial agreement upon when you're almost about to inherit this asset would be a wise choice, just to confirm and have both spouses agree that this source and this funding that's coming through is going to remain separate. How can we help you get started? So if you have any questions regarding postnup, prenup, if you want to set up your trust to make sure that your properties and assets that you leave to your children are protected in case of a divorce, feel free to give us a call. We'd be happy to discuss your situation and customize your plan to ensure that your wishes are fulfilled. Don't forget to subscribe to our channel, and we'll talk to you again soon. Bye-bye.